Hi, my name is Lisa Nyuli. I'm an attorney and partner with the firm of Ariano, Hardy, Ritt, Nyuli, Richmond, Lytle, and Gotel. My primary practice area is family law. And during this COVID-19 pandemic, many people have expressed concerns about how to navigate their cases, their divorce cases through the court system when there's only been limited access that's available. Three areas of concern that clients and other attorneys have discussed and expressed are whether or not they can get a case before a judge right now, whether or not a parent has a responsibility to actually continue to exchange their child with the other parent in spite of the stay-at-home order that the governor had implemented. And then finally, some recent concerns have been with regard to the economic stimulus package and how that affects various families. So first, most if not all of the counties in Illinois have enacted temporary orders that have talked about what kind of access a litigant can have to the family courts. Primarily, the courts are discouraging, if not banning people from being there unless their case is an emergency. And by emergency, the judges are very specific that it has to be a real emergency. And also, if there is an order of protection that's needed, the courts are available for orders of protection. You should be aware that different counties have implemented different procedures for getting orders of protection. Some of them are not able to use the online forms and are requiring paper forms. Some of the courthouses don't have the assistance that litigants would normally have. So it's very important for you as a practitioner to find the local rule that is governing the particular county, because virtually all of the counties have a set of temporary orders and rules in place for dealing with orders of protection, emergencies, and then other aspects of getting to court right now. For example, Cook County is allowing some remote hearings, and the chief judge of the domestic relations area, Judge Dickler, has implemented a frequently asked questions section on the county website that can explain how to get cases before your assigned judge, what types of matters are eligible for assignment and remote hearing. And then in other counties, for example, Kane, DuPage, DeKalb, judges are trying to do at least settlement conferences or enter agreed orders, and doing that access through email and other agreed upon means. So what we're encouraging everyone to do is to make sure you know what county you're in and look at the procedure for that particular county. Because you can do prove-ups and finalize cases. I know litigants have concerns about that. And you can still file new cases. You can still serve process. All of that is still something that is available despite the stay-at-home order. The second area deals with children and how we're handling parenting time and changes between the two parents. I know there was a lot of discussion initially when the stay-at-home orders went into place as to whether or not any ongoing parenting time could even happen. And the governor's executive order actually deals with this in paragraph 14F, where it specifically indicates that necessary transportation includes transporting children back and forth for parenting time and custodial time. So that's the first thing we would look to, and the first thing that's important to know if your clients are questioning whether those things should happen. Beyond that, I think some of the issues are whether or not a child should even transfer households between the two parties. And as with a lot of things in law, this is a little bit of a it depends kind of answer. There are a lot of factors, but generally speaking, several of the courts have issued guidance for attorneys to say that generally speaking, if there is a parenting order in place, litigants are expected to comply with it. So if there's already an order that says the child is to be with dad on Monday, Wednesday, Friday, and with mom on Tuesday, Thursday, Saturday, you're required to comply with that. So if there's not an order, what several of the judges have indicated is that the child or children should be, the parents need to maintain the status quo. Whatever that is, whatever you were doing before the pandemic occurred, if you were sharing time in separate households and there was an informal parenting schedule, whether it was in writing or not, that's what each parent should be doing. The judges have indicated that parenting time issues are generally not going to be considered to be emergencies, and so you're not going to be able to run to court and get a judge to rule on these issues absent any type of order of protection issues. Just general parenting time is not an emergency. At the same time, the judges are certainly going to take into consideration how a parent acted during this crisis. Generally, the judges are going to be of the opinion that parenting time for both parents and to ease a child's stress during a pandemic, both parents are going to be essential in that, and that children should be seeing both of their parents, and that the parties should be able to cooperate at least on that level. Now, we all have contested cases where parents can't agree on the time of day, let alone how to handle parenting time during a crisis. And certainly we have different factors at play. For example, what if one parent is a health worker? What if one parent is an essential worker working in a grocery store or someplace where there's a lot of contact, potentially with people who may be infected? Of course, the parties have to take that into account. Also, if a parent is sick, not necessarily with coronavirus, but with anything, this probably isn't a time to risk your child's health. But generally speaking, the judges have indicated that they're going to look at the circumstances and what decisions people made, and that if one party was just using this unfortunate time to deny parenting time or to modify parenting time without having a good faith basis for doing that, there could be harsh consequences, sanctions, attorney's fees, those types of things. So that's something that's important to keep in mind. And you can find some of the guidance. I know that, for example, DeKalb County put out a memorandum. I believe Kane County also put out a memorandum that indicates how the judges are looking at these things and some guidelines for parents to look at. So you can go online and find those. The third area is the economic aspects of the divorce and how they're affected by the Federal CARES Act. And CARES, C-A-R-E-S, is the acronym for the Coronavirus Aid, Relief, and Economic Security Act, which was signed by President Trump on March 27th of 2020. And that act has some relevance for your divorce clients almost immediately. Part of that is the actual relief and rebate money, and that's probably what a practitioner will get calls on more immediately as the government indicates that the checks are soon to be sent to the parties. So each adult in the family is entitled to up to $1,200 plus $500 for each qualifying child. Now, there are adjusted gross income limitations. And for example, if an individual makes $99,000 annually, they're not going to get anything. So it's primarily for individuals who make under $99,000. The rebates are supposed to be issued soon, and if a party hasn't filed a tax return for 2019, the government is supposed to be using 2018 income and filing status to determine how the payment is going to be made. So if you have clients who filed separately in 2018, whichever party claimed a child, that's how the checks are going to be paid out. If the parties filed jointly in 2018 or 2019, the checks will be issued jointly for the stimulus package. So one of the questions we're getting is, who's the stimulus money going to go to? Is it going to be made payable to both parties? Are all the children eligible? And what happens? How does that get divided? So it's really important right now for practitioners to touch base with their clients and make sure that there's either an agreement in place as to whether they're entitled to the stimulus money, and if so, what are they going to do with it? Are they going to divide it right now? Do we need a court order in place so that the money gets held until we can actually get to court and have a hearing? This would be the type of thing we could do by an agreed order, for example. If we agree that we know X amount of stimulus dollars are going to be sent, we can do an agreed order that says whichever party gets the money is required to hold it until further court order. You would be able to submit that electronically to most judges and they would sign that order. And then you would have the protection that your client needs. So that's an important area that has relevance right now. Another important benefit from the CARES Act relates to the withdrawal of funds from retirement plans. Normally, if a person is under 59 and a half, they have to pay a 10% early withdrawal penalty for taking money out of any of their retirement funds, IRAs, SEP plans, 401ks. We know that in a divorce case, if you transfer money to the alternate payee, who is the spouse, not the participant in the plan, that person could withdraw money without the 10% penalty because it's incident to divorce. Under the new CARE Act, any individual can withdraw money without the early withdrawal penalty up to $100,000 if the purpose of the withdrawal is related to the coronavirus. So that may be something that someone's not working, that they've had to incur additional costs because children are home, or they're not able to pay rent, or there's any number of things that are going to be considered to be directly related to coronavirus issues. So that's something that's available. And any tax that would be owed is still going to be owed on the early withdrawal, but the stimulus package also provides that it can be repaid over a period of 3 years, or the tax can be spread out over 3 years. So it does give families some nice benefits that may be important during a divorce case. And this applies to withdrawals that occurred during tax year 2019. So those are the 3 areas that I think have some real immediate significance for practitioners that are related to this COVID pandemic situation. I hope these tips have provided some guidance for practitioners who are trying to move through divorce cases during this pandemic. If you need any additional information on any of these issues or other COVID-related issues, please make sure to visit the ISBA website. There's a wealth of information available. Thank you.